here with Professor Abbott and Jacob Turner on behalf of the appellant, Dr. Stephen Thaler. My learned friend, Dr. Barron, appears on behalf of the respondent, the Comptroller-General of Patents, Designs and Trademarks. There was an issue that we needed to discuss in respect of the admissibility of the supplementary bundle.
Very briefly, I mean, the concern of the court is that this has come in very late.
Yes. I can advise you that the respondent has withdrawn his objection to the supplementary bundle. If you'd like...
I won't detain you then if the objection is withdrawn. I mean, whether technically one needed to make the supplementary submissions may be debatable. It might have been quite adequate for you to add the authorities you wanted to your list and then make your oral submissions. But be that as it may, I won't detain either of you if you're agreed that those authorities are before us and the supplementary submission is as well. You may proceed with your submissions.
May I ask, my lords, we have hard copies of the supplementary bundle, if you would require those.
I think we have it in electronic form.
Yes, you do.
Which is all we need.
Fine, thank you.
Thank you very much.
My lords, the issues in this appeal are as those set out in the agreed statement, which is at pages 20 to 22 of the bundle, specifically at page 22. Put briefly, they relate to the question whether patents may be granted to Dr. Thaler under the provisions of the Patents Act 1977 for two inventions generated by an AI system known as DABUS in the absence of a traditional human inventor. I propose first to address your lordships briefly in connection with a number of points pertaining to the two British patent applications that have resulted in these appeals, and also in connection with some observations made by the Controller in his written case. I then propose to address issues B and A in that order. The reason for this is that issue B lies at the heart of the substantive provisions of patent law, while issue A relates to a procedural requirement for obtaining a patent. Professor Abbott will then address you in connection with issue C, the policy points raised by the respondent and pertinent to this case, as well as in relation to points on statutory construction. The two patent applications are at tabs D and E of the main bundle, and I propose just to go through these very briefly, if I may.
We don't have tabs. All our papers are in electronic form. So if you could give us the electronic page number.
Yes, page 173. This is the front cover of the first patent application, and it relates, as you can see in the front cover, to a food container.
I do apologise, of course, we have them in... You gave us a rather large set of key documents, so we do have it in paper form as well.
You do as well, yes, indeed. This is page 173, and the first invention relates to a food container. So, in other words, the invention relates to a product. And in the Court of Appeal judgment, Lord Justice Burse, paragraph 91, that's at page 90 of the main bundle, referred to some inventions being products in accordance with section 60 of the Act. This application has been through substantive examination at the Patent Office, and the relevant documents commence at page 194 of the bundle, the first search and examination report from the Patent Office, in which at pages 196 and 197, it can be seen that the examiner raised some objections to the patentability of the claims as originally filed. And in particular, he raised lack of novelty objections in respect of claims 1 to 12, and that's at item 1 of the examination report, and at item 6 at page 197, the examiner raised a lack of inventive step objection against claim 13. There followed the reasonably typical exchanges between ourselves, the patent attorneys, and the examiner, and these appear from pages 198 to 204. And we can see at 198 and to 200, there's a response to the examination report, some amended claims were filed, some amendments, some arguments in support of the invention were made. At page 201, there's a further examination report by the Patent Office. At page 203, further objections which were raised. They were then responded to at page 204. At page 205, the examiner issued what we would term the no further objections letter. So after a number of exchanges during substantive examination, the examiner issued a communication saying, at present, I have no further objections to your application, but I cannot complete my investigations until at least 3 months after the application has been published.
That's dealing with things like novelty, adequacy of the description,
very much so. So
obviousness and so forth.
Indeed. So these are the substantive requirements to patentability, had been dealt with in substantive examination. And it is common in applications of this nature that the application will proceed to grant without further objections. The additional examination the examiner will carry out is to look through patent applications which may have an earlier filing date but weren't published at the time he carried out his examination. So he carries out a top-up examination. There's a statutory period for third-party observations. If nothing comes about by that top-up examination, the patent is granted. A similar set of circumstances occurred in respect of the second patent application. The front cover of that is at page 218 of the bundle. This invention relates to an emergency light beacon, and as it happens, there are also claims to a method of operating a light beacon. And the examination history can be found between pages 247 to 271 of the bundle. I don't propose to take my lords through this, save to identify at page 272 of the bundle, the examiner in charge of that application issued the similar no further objections letter. So after amendments and arguments, the examiner was satisfied that the applications met the substantive requirements for patentability. Since both applications have been deemed following substantive examination to cover patentable inventions, we say that an invention has a deviser or creator. And in these proceedings, there's never been any suggestion that these inventions have come about without something, or creating the inventions, without a deviser. Dr. Thaler contends that both applications were created autonomously by the artificial intelligence system that is known as DABUS. Dr. Thaler also contends that he's entitled to the rights to the DABUS inventions by being the owner as well as a creator and operator of DABUS. The Patents Act requires, and this is at section 13 of the Act, it's at page 298 of the bundle, that an applicant files a statement identifying the person or person whom he believes to be the inventor, and where the applicant is not the sole inventor, must indicate his derivation of his right to be granted the patent. If the applicant fails to do so, in other words, if the applicant fails to file the statement, the application should be deemed to be withdrawn. Dr. Thaler, for each application, filed 2 Forms 7, and I'll refer only to those of the first application because the facts are mirrored in the second application. And if I may refer, my lords, to page 206 of the bundle, we can find that there's a letter from ourselves to the Patent Office. Form 7, which is at pages 207 and 208 of the bundle, this is a typical way of satisfying section 13 of the Act, is by form. And the form was also accompanied by an addendum, which appears at pages 209 to 212. The controller objected to that first filed form, and the objection is at page 212 of the bundle. In response to that, an amended Form 7 was filed, and that appears at pages 215 and 216 of the bundle, and I will take my lords through that in a bit more detail in a moment. The events of the second application, as I said, mirrored those of the first application, and it's not necessary, I don't think, to go into detail with those. There was only one difference in the procedure of the two applications, in that the first application passed through substantive examination and reached the, shall we say, no further objections letter before the first Form 7 was filed in respect of that application. The second application, on the other hand, continued through substantive examination after the filing of Form 7 in both its versions, the original version and the second version.
Does that make any difference for our purposes?
I submit it does, my lord, because what it does is it demonstrates that the substantive examination of both applications is separate from the designation of the inventor. And in fact, this is a point which Lord Justice Burse picked up on at page 87 of the bundle. And this is at paragraph 73 of his findings. And what Lord Justice Burse said at page 87 was taking grant first, a patent is granted if the examiner reports to the controller that the application complies with the requirements of the Act. That only happens after substantive examination, in which the examiner is required to investigate, to such extent as he considers necessary, whether the application complies with the Act. Compliance with the Act is defined in Section 1. None of this involves an examination of the applicant's right to be granted a patent. The same occurs in respect of a refusal of the application, and that is in a subparagraph 2 of paragraph 73 of Lord Justice Burse's judgment, where he states, lack of entitlement to grant is not a ground of refusal. Section 13.2 is expressly not a designated formal requirement. If I may take my lords to the amended Form 7, that's at page 215 of the bundle, and in particular the second page of that, which is page 216, the form identifies DABUS in the inventor box and states the invention was autonomously generated by an artificial intelligence. The form also has an added statement that states the applicant identifies no person or person whom he believes to be an inventor, as the invention was entirely and solely conceived by DABUS. Pursuant to Section 7.3 of the 1977 Act, DABUS is the actual deviser of the invention and therefore rightfully named as the inventor on this patents form in accordance with the requirements of Section 13 of the Act. So in other words, Dr. Thaler did not identify a person, and that goes to some of the issues that we'll need to be discussing. If I may also take my lords to the addendum briefly, and that is at page 209 of the bundle. The first paragraph of the addendum explains how the makeup of DABUS. The second paragraph explains that in the case of the present invention, the machine only received training in general knowledge and in the field and proceeded to independently conceive of the invention and to identify it as novel and salient. In the next paragraph, it is explained how an AI system may, or how an invention may come about, and Dr. Thaler explains, however, in the present case, DABUS was not created to solve any particular problem, was not trained on any special data relevant to the present invention, and the machine rather than a person identified the novelty and salience of the present invention. The controller, in his decision, and this is at page 139 of the bundle, this is the decision of the 4th December 2019, at paragraph 27, at page 139, the controller states, given the clear statements provided by the applicant which indicate that the inventor is in fact an AI machine, it seems that it will be almost impossible to demonstrate that the actual device of the invention was in fact a person as opposed to Dabus. And just for the record, at paragraph 15, at page 137, last sentence of paragraph 15, the controller says, to be clear, the office accepts that Dabus created the inventions set out in the two applications. Now, while Dabus being the creator of the inventions is not an issue in these appeal proceedings, in the respondent's written case, an objection to our application for permission to appeal, it seems that the controller is seeking to resile from that. If I may refer, my lords, to page 55 of the bundle, and this is in paragraph 55, subparagraph C, where the controller is discussing the outcome of the government's consultation on AI inventions, etc.
Beg your pardon, I think I've missed the page.
Oh, it's page 55, the bundle.
Paragraph.
Oh, sorry, paragraph 50, page 55 of the bundle, paragraph 50C. Respondent states, there was no support for the view that AI is in fact not sufficiently technologically developed to invent without human intervention. So the factual assertion, which this appeal must assume to be true, is at least a controversial one.
Well, that's not resiling from the concession at all, because the controller is saying to us that we have to make the assumption that statement is true. But yes. All that the controller is there saying is that the result of his researches has shown that there are people who are knowledgeable of this world, yes, who think that the AI is not yet at a state yes, which can achieve that autonomous inventiveness. But we have to decide the case on the basis that what is said in paragraph 15 and 137 is the case. We have to assume, for the purposes of this hearing, that Dabus created the invention.
I'm obliged, my lord. Well, my concern is that statements of that nature may cause you to think that maybe there isn't a real reason or proper reason why we're here, and it may be based on an assumption. And I'd like to make the point. We
sometimes have to decide cases, yes, based on assumptions. And
if maybe
one of those.
Yes, no, thank you, my lord. If maybe I could potentially dispel that notion that our AI systems are not able to invent, and if I could maybe refer my lords to page 159 of the bundle.
Sorry, which page?
159. And this is the IBM document that was annexed to the objection to the application for permission to appeal. And it's the second paragraph that reads, for example, AI is able to find relationships between many parameters, but cannot independently recognize or confirm the value of such relationships, and thus has no cognition that an invention has been made. Even AI with the ability to adjust algorithmic coefficients, in a sense reprogramming, has no appreciation of the technical or societal value of those adjustments absent humans. So that is the limitation of the system that IBM was referring to and that the respondent referred to in the objection. Now, I submit that it is that there's a limitation to that IBM system that DABUS does not have. And I had directed my lords to page 209, the addendum, which explains that DABUS actually has a mechanism to identify itself the novelty and salience of the present invention.
Salience, you mean practical application?
That's indeed what is. It's in the first paragraph of page 209. It's explained that it's got a neural network that identifies the most novelty, utility, and value of what comes out of the machine. We've also included in the bundle a transcript of a
in answer to Lord Kitchen's questions, when you use the word salience,
yes,
to what are you referring?
I think it's the value of the invention. So there are two networks. One that says actually you've generated a lot of output that may be inventive. This has got utility. This has got value, and therefore identify that as something that's worthwhile.
Value in the broader sense. It's not a monetary value.
No, in the broad sense.
Practical application.
Yes.
Is that right?
Indeed. Yes, very much so. And we've included in the bundle also, at pages 773 to 776, a transcript of a presentation given by Beat Wiebel, the Chief IP Counsel and Group Senior Vice President of Siemens, which he gave at a WIPO conversation on intellectual property in September 2019. And of relevance is really what he explains at page 775. And there's in the bundle, there is a screenshot of what he is talking about at that time. And he says he's talking about AI being involved in the design of vehicles and vehicle components. And in the last paragraph that starts, however, he says on the left-hand side shown above, and it's getting really interesting in my view, you can see two examples of AI-created inventions. He first of all talks about a chassis, then he says, you see a suspension. The green one is man-made, casted suspension as it would traditionally be made today, and the right one is a 3D printed AI designed suspension of the same type. If I now talk to the people having kind of triggered this process, they say on the one hand it's different, and I hope that you'll all agree it is different, it looks different, it is in my view, it's new in my view, it's new. And at page 776 he continues, it's a different suspension than the green one, and the experts tell me we do not really understand, or we were surprised why there is this mechanical interconnection between the two eyes on the right-hand side. So this is, in my view, very surprising. You can call it a non-obvious feature of the suspension. So that means that an AI system in this example has created a novel, non-obvious device, and why shouldn't that be patentable? Because because the problem we lack an inventor. We have heard it several times. We lack a natural person as an inventor, and on the other hand, if you didn't allow this AI-created suspension to be patented, we would discriminate an entire technology just because of the fact it has not been created by a natural inventor. I submit that Mr. Wiebel is identifying precisely the point that we have at the moment. And indeed, in the government consultation, at page 732 of the bundle, the consultation, and this is at paragraph 2, the consultation indicates some believe that AI will soon be inventing and creating things in ways that make it impossible to identify the human intellectual input in the final invention or work. Some feel this is happening now. Therefore, submit that this is a problem that really we ought to be addressing, because it's a real-life problem, not something based upon assumption in this particular case. If I may, please, my lords, move on to issue 2. does the 1977 Act provide for the grant of a patent without a named human inventor? I submit, my lords, that there is no such requirement in the Act that states that an invention must have a human inventor to be patentable. Even if the Act assumes that an inventor is human, that does not constitute a substantive requirement to the grant of a patent, nor a bar to the grant of a patent for an AI-generated invention. We've already touched upon the substantive requirements for patentability, which are set out in sections 1, primarily in section 1 of the Act, but also in conjunction with sections 2 to 4A. None of these provisions make the nature of the inventor a requirement for the grant of a patent. Section 13 is a procedural requirement only and relates to the filing of a form. This is indeed consistent with the findings of Lord Justice Burse in summary at paragraph 97, subparagraph 5 of his judgment, and this is at page 92 of the bundle, where Lord Justice Burse states, the fact that the creator of the inventions in this case was a machine is no impediment to patents being granted to this applicant. And Lord Justice Burse correctly reflected UK law at paragraph 73, which I've already taken your lordships to. I submit also of relevance are the provisions of the European Patent Convention, in particular Article 52 and Rule 19 of the European Patent Convention. The UK is bound by these by virtue of subsection 7 of section 130 of the Act, and we've included that in the bundle at page 334. Subsection 7 is at page 337. And in summary, what that states is that sections 1 to 4, or rather section 1 and 2 to 6 of this Act, plus some others, are so framed as to have as nearly as practicable the same effects in the United Kingdom as the corresponding provisions of the European Patent Convention. Article 52 of the European Patent Convention, which I've provided at page 356 of the bundle, states European patents shall be granted for any inventions in all fields of technology, provided that they are new, involve an inventive step, and are susceptible of industrial application. While Article 81 of the European Patent Convention, and this is at page 362 of the bundle, states that the European patent application shall designate the inventor, the operative provisions of that article are relegated to the implementing regulations, and that is Rule 19, that is at page 365 of the bundle. Paragraph 1 of Rule 19 states that the designation shall state the family name, given name, country and place of residence of the inventor, and subsection 2 says...
Could you give me that page number again?
365.
365.
And the second part of Rule 19 says the European Patent Office shall not verify the accuracy of the designation of inventor. UK, also relevant to the UK law, of course, are the Strasbourg Agreement and also TRIPS. And they've provided the bundle at pages 371 and 373. And it's, I think, only worthwhile saying that these provisions also do not make the nature of the invention a substantive requirement for the grant of a patent.
The nature of the invention?
Inventor.
The inventor, yes.
Thank you, my lord. We have, my lords, an authority which I submit can assist my lords in reaching a decision today, and that is the Board of Appeal decision, J8 of 20, which is provided at at page 485 of the bundle.
You may have very briefly to say a little bit for the benefit of my colleagues about how the Board of Appeal works and what it is deciding.
Yes, so the Board of Appeal, in this particular instance, it was the Legal Board of Appeal of the European Patent Office that heard, we filed parallel cases in Europe for the two applications that I've taken to you to this morning. Those applications also designated Dabus as the inventor. The applications were refused. They went up to the Legal Board of Appeal, which then heard our case and issued a decision on the European applications. As it happens, and I will take my lords to this shortly, the Legal Board of Appeal had in sight the decision of the Court of Appeal that this appeal comes from in reaching its decision. So the facts of the case, and again I'll take my lords to the facts briefly, are the same as the case that you have in front of you today. At page 510 of the bundle, and this is at paragraph 4.6.2 of the decision, the Legal Board of Appeal states, firstly, yes.
Yes, which
States, firstly, under Article 52(1) EPC, any invention which is novel, industrially applicable, and involves an inventive step is patentable. That goes to the point I've been making. The appellant has argued that the scope of this provision is not limited to human-made inventions. The board agrees. How the invention was made apparently plays no role in the European patent system. The board then goes on to talk briefly about Article 53A EPC, but a little bit further down in that paragraph, the line starts with the numerals 5.6. The board says, therefore, it is arguable that AI-generated inventions, too, are patentable under Article 52(1) EPC. As it happens, there was a parallel decision of the Legal Board of Appeal. The number of that is J9 of 20. In respect of the second European application, the proceedings were not, or the decisions were not consolidated, but the decisions are identical in that regard. If I may also refer to the travaux préparatoires to the EPC, which are included in the bundle, and I'll give my lordships the...
Sorry, do we need to read on a little bit in the passage that, from the passage you've just referred us to in the Board of Appeal decision?
Yes.
You've referred us to one extract, but that's not the full extent of the reasoning, is it?
In terms of, is my lord referring to 4.6.3?
Or 4.6.6?
Yes.
Yes, I'll be taking my lords to that in due course. I can address it right now.
Whatever is convenient, but
yes,
there was rather more to it than you pointed us to.
Indeed. I will not be leaving it out.
Okay.
Well, if you are founding on this decision, we need to see the words that you are relying on in a wider context.
Yes.
Of the decision as a whole. Otherwise, you're just island hopping between various statements. That's
fine, my lords. I can address that point right now. And is my lord referring to 4.6.6?
Well, I cast my eyes right through from the passage you took us to through to 4.6.7.
Yes. Would my lord like me to discuss all of the issues from what the part I've just quoted down to the end of that? I'm happy to do so now.
Please do.
Yes. Okay. The board continues at 4.6.3 saying, secondly, filing a statement on the origin of the right to the European patent is a requirement under the EPC where the inventor and applicant differ. It is only a formal requirement. Its function can reasonably be seen only as informing the public on the possible origin of any of the right. There's a reference to the Board of Appeal decision and Nippon Piston Ring's application. The board then continues, it would be disproportionate to deny protection to patentable subject matter for failing to fulfill such a formal requirement. This is because of the limited additional utility which the statement may have for the public or the individual parties, and in view of the absence of a full examination on the actual merits of the European Patent Office. So what the board is saying is that there isn't a de facto prohibition to the granting of patents for inventions generated by AI systems. The issue lies with the indication of the inventor, but the board indicates that it would be disproportionate to deny protection for subject matter that would otherwise be patentable simply in relation to the requirement for naming the inventor. At 4.6.4, the board continues to discuss that the legislator probably only had in mind human-made inventions when drafting Article 60 and Article 81 EPC, and we don't deny that. These acts are quite old at the moment. The board could provide that no statement on the origin of the right is required when an application concerns an invention developed by a machine, or accept any statement irrespective of its content. Where the board would not be ready to go that far, it would at least have ex officio to refer questions to the enlarged Board of Appeal. That's a request that was made in the European appeal proceedings. At 4.6.6, the board then continues on the topic of who should you put down as an inventor. The board specifically states, the board is not aware of any case law which would prevent the user or owner of a device involved in an inventive activity to designate himself as inventor under European patent law. The EPC in turn does not prevent the applicant from providing information in the application which is not relevant for carrying out the invention, but may satisfy the fairness concerns identified by the appellant in the addendum of 24 July 2019. That addendum is the same as the addendum that was filed in respect of the UK applications. And then the board goes on to say, secondly, it is the task of the lawmakers to amend the EPC and to assess whether a real problem exists. Different solutions may be conceivable to the issue raised by the appellant. It's not for the board to select one of the possible approaches. So what the Legal Board of Appeal has done, in effect, said, well, there's an issue with naming Dabus as an inventor, and I will take my lords to actually what the real issue was in a moment, because there's some curiosity to that. The Legal Board of Appeal suggests a solution of naming Dr. Thaler as the inventor, but it is it's an agreed position that Dr. Thaler is not an inventor, and indeed the addendum says just that Dabus made the inventions. So what the Legal Board...
I don't see that that's inconsistent with him being an inventor.
I think when we come to subsection 3 of section 7 of the Act, and if I may take your lordships to...
but just before we leave this, exactly where did the Board of Appeal come out on this? So I understand it, they said, well, this is something we can't ignore. Is that right?
The paragraph you didn't read on 4.6.5 says that having considered these objections, they can't accede to them. It would involve fully ignoring a formal requirement of the EPC. Yes. And then they give the reasons why they can't do that.
It would help, perhaps, my lords, if I show you what the board was referring to in respect of the application itself. And if I may go back a little bit, in particular, at page 508 of the Legal Board of Appeals decision. And what happened in Europe is you can in Europe file a main request and auxiliary request. If the main request fails, you can rely on a backup position if you wish. And the auxiliary request appears at page 278 of the bundle. And this is the EPO designation of inventor. As you can see here in the middle of the page, it says the applicant identifies no person or person whom he believes to be an inventor as the invention was conceived autonomously by DABUS, an artificial intelligence machine. The applicant has a right to the European patent by virtue of being the owner and creator of DABUS. And you can see on page 279, there is an addendum which is similar to the UK one. At page 508, this is paragraph 4.4.1 of the Legal Board of Appeals decision. The Legal Board of Appeals says, the auxiliary request relies on the argument that Article 81, first sentence EPC, does not apply where the application does not relate to a human-made invention. The board agrees with this approach. Provisions concerning the designation were drafted to confer specific rights on the inventor. It is arguable that where no human inventor can be identified, then the ratio legis of Article 81, first sentence, does not apply. So the board specifically indicated that it agreed that you didn't have to name a person in the case of an AI-generated invention.
The next paragraph.
The next paragraph goes on to discuss, and it may help if I...
it's the subparagraph of 441 that I'm referring to, the fact that where the inventor and applicant differ, however,
yes,
a statement on the origin of the right of the European patent is necessary under Article 81, second sentence.
Yes. If I may refer, my lordships, to page 362 of the bundle, and this is Article 81 of the European Patent Convention. That has got two requirements. The first is to designate the inventor, and then if the applicant is not the inventor, the designation shall contain a statement indicating the origin of the right to a European patent. So the objection that was raised to the auxiliary request was not in connection with the failure to name a person.
Well, it was. All they accepted was it was arguable, and then they went on to the second point.
Yes,
you can't treat that as having accepted the point.
Okay, be it as this may, I mean, the board does say it agrees with the approach, but I submit that the real issue comes about from a lack of, or rather not naming a person, having an AI system and as accepted as the inventor, and then how does Dr. Thaler derive the right to be granted the patent, which is a second sentence of Article 81.
But the upshot of all that you've shown us is that the present position of the Board of Appeal is rather similar to that of the majority in the Court of Appeal in this jurisdiction, is it not?
Apart from, my lords, there are two elements to this, my lords. The first is that the issue of entitlement, as the Board of Appeal identifies, is in relation to Article 60 of the European Patent Convention, which sets out how an applicant may derive the rights to an invention. What is lacking in Article 60 is the other rule of law that appears in Section 7.2b of the 1977 Act. So in Article 60 of the Act, which my lords will find at page 357 of the bundle, it states that the right to European patent should belong to the inventor, successor in title, or employer. There's no other rule of law. And the Legal Board of Appeal explains the limitations of Article 60. And at paragraph 4.2.2, at page 504 of the bundle, first of all, the Legal Board of Appeal acknowledges that issues of entitlement are determined by the national courts. They also say, therefore, even if, for example, the UK or Australian law provided for other forms of acquiring originally or deriving the right to the patent, such as possession, and these forms went beyond the scope of Article 61, as suggested by the appellant, these rules would apply to domestic applications, but not to European patents.
How does any of that help you?
It helps, my Lord, in that the Board of Appeal has said that it's arguable that you do not need to name a person as the inventor if the invention is generated by an AI system. According to Article 60 EPC, the issue comes with the question of entitlement. What we say is that the UK Act differs because Section 7.2b of the Act enables, in this case, we say Dr. Thaler, to be entitled to the grant of the patent by another rule of law.
But I'm really not sure what we're getting out of the European material you're showing us. Because, I mean, you've just pointed to a difference with the statute with which we're concerned.
Yes, indeed.
But Article 60, in any event, talks about a patent belonging to an inventor.
Yes.
So how can a patent belong to a machine?
We've never suggested that a patent could belong to a machine.
Article 60 again? What page is Article 60?
It is page 357.
357.
It has never been Dr. Thaler's position.
It says the right to a European patent shall belong to the inventor or his successor in title.
Yes.
How can the right to a patent belong to a machine?
It has never been Dr. Thaler's case that Dabus has any right whatsoever to the patent. It is Dr. Thaler's case.
No, we know it's not his case. Your case is that you wish to extend the common law concept of accession to gain that right by ownership of Dabus.
Yes.
But what Lord Richards is putting to you is Article 60
Yes.
has certain requirements, and it has to be the right to the patent has to belong to the inventor,
Yes.
the successor in title, or the employer.
Yes, indeed. And there's a distinction, my Lord, between Article 60 of the European Patent Convention and also Section 7.2 of the...
I appreciate that, but
Yes.
what I'm trying to ask you is what do we get out of this European material? Because
Yes.
it does appear to me on the face of it, at any rate, that Article 60
Yes.
1 is simply inconsistent with your case. Now, you're entitled to say, well, that's the European Patent Convention. We're not concerned with that. But
Yes.
I'm baffled as to why we're even going to it.
It comes about, my Lord, at paragraph 4.6.6 of the Board of Appeal decisions. That's at page 502, where the board says it is not aware of any case law which would prevent the user or owner of a device involved in inventive activity to designate himself as the inventor.
Well, that's the point, but that's exactly what Dr. Thaler does not wish to do.
Well, it doesn't, the board doesn't say that it can't be done.
No, but that's what he doesn't want to do and very demonstrably hasn't done.
Yes.
So, I mean, I
much
don't
so.
see how that helps you.
I think it helps, my Lord, in the way that if Dr. Thaler puts his name down as inventor, when he's not an inventor, and he can file an addendum that says, I'm not an inventor.
But he can't put himself down as inventor and then file an addendum saying he's not the inventor.
The suggestion appears to be, from the Legal Board of Appeal, that one can do that. And may I direct...
Sorry, where in this document does the Board of Appeal say that the applicant can state that he is the inventor and then lodge an addendum contradicting himself?
Well, I think, is it not in 4.6.6, my Lord, where it says it's not aware of any case which would prevent...
Which page?
This is
Page 502.
512. board is not aware of any case law which will prevent the user or owner of a device involved in an inventive activity to designate himself as inventor. It doesn't go on to say, and then contradict himself.
Well, what it does say is that he can file an addendum of 24 July 2019.
Has Dr. Thaler ever made an application explaining that he's used DABUS to carry out the creative activity, if that's how you would wish to call it, and made an application in his own name as the owner of DABUS, explaining his relationship to DABUS and how he set it off on this course?
My Lord, there is, and there's a pending European application at the moment which is under examination at the European Patent Office. But precisely along those lines.
No such application has been rejected?
No.
By any office?
No. So there's a pending European application where Dr. Thaler designates himself by virtue of being the owner of DABUS and explains how DABUS came up with the invention.
Designates himself as the inventor.
Yes,
yep.
Indeed. And if I may direct my lords to paragraph 105 of the Respondent's statement. This is at page 64 of the bundle. So this is in relation to page 63, paragraph 104, talks about the EPO solution arising from the decision of the Legal Board of Appeal. And at paragraph 105 at page 64, the Respondent says, the same is true in the UK, as the 1977 Act also provides no such mechanism. If a person had been identified for section 13.2a in respect of the applications, perhaps even with a statement in the patent specification that this invention was devised with the use of an AI called DABUS, then we accept the controller would have no grounds to deem these applications withdrawn.
Yes. Now, what possibly could be Dr. Thaler's objection to following that course?
Dr. Thaler does not say that he's actually made the invention. So, ultimately it lies with section 7.3 of the Act, which states. In this Act, inventor in relation to an invention means the actual deviser of the invention, and joint inventor shall be construed accordingly. Lord Hoffman in Yeda held just the same, and if I may refer my lords to Yeda, that is at page 466 of the bundle. And this is paragraph 20 of the judgment. Lord Hoffman says, the word he's referring to section 7.3 of the Act, the word actual denotes a contrast with a deemed or pretended deviser of the invention. Dr. Thaler says that he did not come up...
You perhaps should read on the rest of that sentence.
Oh, yes. The natural person who came up with the inventive concept.
It means the natural person who came up with the inventive concept.
Yes, and that's
the difficulty you're facing on this appeal.
It is indeed, my lord. That is right. But it answers the question why we say it is wrong for Dr. Thaler to name himself as an inventor.
No, I follow that.
If he's not the actual
If he says he didn't invent it, then he can't, in good conscience, name himself.
And that is precisely the case. There's also an additional issue that Dr. Thaler happens to be a US citizen, and in US law, it's an offence to name yourself as an inventor if you didn't actually make the invention in respect of a US application. So Dr. Thaler doesn't want to put something on the form which he knows to be untrue.
Yes. Well, this isn't a US application, so he's not going to be bothered with that.
Yes. No, indeed. And what our submissions will go on to say, well, in the case where an AI system has made the invention, can the law be construed, since time has moved on, can law be construed to, in effect, identify either the correct the true creator of the invention, or can it enable not naming a person at all, as Dr. Thaler has done in Amended Form 7. If I may briefly address my lords on this point.
I mean, he could argue, at least, couldn't he, that he was the natural person who came up with the inventive concept by using a machine which produced it for him.
I submit, my lord, that sort of stretches the concept of inventor, possibly beyond its traditional understanding, rather than identifying the actual deviser of the invention. There is an importance with identifying the actual deviser of the invention, and this really comes about by Section 13 in conjunction, for example, with the sections which give the inventor rights to an invention, where it is important to identify how the invention came about, so who or what invented it, how the applicant claims to derive the rights, because it is on that basis that someone else may make a claim, for instance, under Section 8, Section 12, or 37 of the Act, and it is providing the information that is necessary, that is true in terms of the making of the invention, and which is necessary for a third party to say, actually, I should be the inventor, or I should own rights to this patent for one reason or another.
None of that's going to be interfered with by adopting the form of wording that you've just shown us, and that the controller has indicated that the office would find acceptable.
My lord, it is all very well, I submit, in this particular case where Dr. Thaler owns a machine, Dr. Thaler is an individual. But in the case, and this is, I submit, would be the majority of cases, the AI system would be owned by a company. You'd be putting down, you wouldn't be able to put down the company's name as the inventor. You'd need to put down a person as the inventor. They'd have to identify who, because that person would only be a deemed or pretended deviser. But the Act provides rights to the inventor, and we then end up with the issue of a named inventor purporting, according to the letter, the wording of the Act, to have certain rights, for example, rights of compensation, maybe even rights of ownership under the employment provisions of the Act, Section 13.
Would that be a problem if Dr. Thaler were employed by a company? Because Dr. Thaler would still, on that premise, be the inventor, but any rights might, as a result of the employment contract between Dr. Thaler, or the ownership of the machine and the company, vest in the company.
Potentially, but would that still deny Dr. Thaler the option of making a claim for employee compensation? And I submit it would do, because he's designated as the inventor just in effect for the purpose of satisfying a form. And that's really what I submit we're talking about here, is the purpose of satisfying a form. So if Dr. Thaler puts his name down as inventor when in fact he is not, I submit that takes in effect, a reworking, a construction of this provision of the Act. And as a consequence of that, we also need to reconstrue the other sections of the Act, in effect to say, well, Dr. Thaler, you're not a real inventor in this instance, so you shouldn't have the right, for example, to own inventions that are not within your realm of employment of your employment agreement. You shouldn't be entitled to compensation under the provisions of, for example, Section 39, because you're only a deemed or pretended deviser of the invention. So I submit that by putting Dr. Thaler's name down as inventor, that is actually stretching the Act, I submit, more than identifying the actual deviser of the invention and saying that the applicant cannot name a person as the inventor. If I have...
I suppose the controller is indicating what would be acceptable, but not suggesting that Dr. Thaler should put down something which is untrue. He said, if this is true, it's acceptable. But he's not trying to persuade Dr. Thaler to say something which Dr. Thaler believes to be untrue.
If that is the case, my lord, the reference was to the suggestion by the Legal Board of Appeal, which specifically referred to the addendum filed in July.
All right, okay, but
yes.
I mean, it's a simple point.
Yes.
Dr. Thaler is not willing to say something he believes to be untrue. And the assumption on which we have to proceed is that the inventions were created by the AI system.
Indeed, my lord. And then the question is how do we then address the provisional provisions, or the provisions of Section 13, which are procedural step. And may I remind my lords that Section 13 relates to the filing of a statement, and the sanction is not refusal of an application in terms of that statement, but is deemed withdrawal of the application if the statement is not filed. So I submit that there is an issue that needs to be discussed and decided by your lordships in respect of the facts of this particular case and in relation to the Patents Act. If I may pass to Professor Abbott, who will discuss the issues of entitlement and construction of the Act. If I may do that, unless...
Well, thank you very much, Jim. Professor Abbott.
May it please your lordships, thank you so much for this. I propose to address issue 3. I just want to make one or two brief comments to put my colleagues' points in context and why we took it to the European decision. UK law requires an inventor to be the actual deviser of an invention. European law here rejected the application we filed, but in so noted that inventorship is not a substantive requirement for patentability. There was a failure to meet a procedural requirement, and the board's view was that this shouldn't prohibit patentability. But in the board's view, under European law, Dr. Thaler could name himself because there's not a European requirement that an inventor be an actual deviser. They said the owner of the AI machine could be an inventor, right? But our submission is that is inconsistent with the principles of UK law. And so while someone who simply owns an invented machine could list themselves now as an inventor in Europe, that approach would not be appropriate in the United Kingdom or in other jurisdictions like the United States. And we have limited time, so I don't want to take us to the facts of this too much, but briefly, the addendum explains that Dr. Thaler invented DABUS, provided it general training, and it invented two things in fields not thought of by Dr. Thaler. The value of the inventions was recognized by the machine and not him, and he played no role in the conception of the inventions. So we submit under UK law that does not qualify him to be an inventor in fact, right, and therefore not an inventor in law. One of the major problems the European Board of Appeal had with this was the entitlement provision, because the law is different there. You note it says successor entitle. Well, Section 7(2)(b) of the UK Patent Act is very different, because it allows entitlement by virtue of any enactment or rule of law. And I submit that is an extremely broad basis for entitlement, not even necessarily requiring a UK rule of law, but potentially a foreign one. So in answer to the question of, in the case of an invention made by an AI machine, is the owner, creator, and user of that AI machine entitled to a grant of a patent for that invention? I'd like to break that down into a few sub-issues. The first being whether there's a property right in an invention. The second, whether Dr. Thaler is entitled to the invention or that right under Section 7(2)(b). And then thirdly, regardless of whether there is a rule of law that would apply in this case, whether the Patent Office was nevertheless wrong to deem the application withdrawn based on how Form 7 was filed. So to the first issue, a patent is personal property, a patent application is personal property, but so too is an invention even before an application is made. Now, the precise nature of that property right is, I submit, somewhat under-theorized, because there has not been a need to determine the exact nature of the right, whether it's property per se or an inchoate or a quasi-property right, but the right is clearly there. And the most obvious basis for this is found in the Patents Act itself, which in numerous sections, as we've outlined in our case, refers explicitly to the property in an invention as distinct from the property in an application or in a granted patent. To point the court to a few examples, if my lords would kindly have a look at Section 7 of the Patents Act, which is in tab G, which is on page 293.
Well, insofar as you're referring to documents within the key bundle, we do have tabs, but when it gets to the authorities, we don't.
Fair enough.
We do have Section 7.
Thank you, my lord. Section 7.2b allows a patent to be granted to, according to the material parts, any person who was, at the time of the making of the invention, entitled to the whole of the property in it. To give just one more example, Section 41, which is at page 309, subsection 1ci refers to the property or any right in the invention. Subsection 2b refers to the property or any right in the invention. Subsection 3 states in part, where the Crown or a research council in its capacity as employer assigns or grants the property in or any right in or under an invention, patent, or application for a patent. So you see, this section specifically differentiates between the property in an invention, the property in a patent application, and the property in a patent, these being three separate types of property. Consistent with an invention being property, the Act also specifies that an invention may belong to a person. As we're already here in Section 41, subsection 4 states an invention which has always belonged to an employer. Subsection 5 says an invention which originally belonged to him. And there's similar wording in sections 39 and 40. So unless my lords would like me to take them to those sections which are listed in our case, I'll leave it at that. But I submit there's no cause to look outside the four corners of this statute to see that there is a property right in an invention. But of course, it's also a very common commercial practice. There will be an assignment of an invention, including the right to apply for a patent. And if there was no right in an invention, how could an inventor have a right to apply for a patent or an employer? Lord Walker and Yeda referred to this property right as a sort of inchoate property right, as Lord Justice Burse noted in the Court of Appeal decision. Lord Justice Burse also noted in his view the precise nature of the right didn't matter in practice, at least with regard to this case, because Section 7.2 applies to whatever right there is in the invention. For our purposes, I just seek to note a few of the sticks that are part of this bundle of property rights. First, that it can belong to a person. Second, that it is freely alienable. And third, that whatever else it includes, as Lord Justice Burse noted, the right must include the right to apply for and to be granted a patent in the invention.
Do you have any explanation as to why Section 30, subsection 1, designates a patent or application of a patent as personal property, but is silent as to the invention?
No, my lord. But these other sections I would
I appreciate that.
Right. Now, the majority of
the notion that there is a right in this invention before a patent is applied for isn't a difficult one, is it?
Well, I don't believe so, my lord, but I believe that the majority in the Court of Appeal and Lord Justice Arnold, in reference to Merrill Dow v. Norton, where an invention was referred to as information, held that an invention was just information, and information that is confidential isn't a property right per se. Right? And so this was, in my view, the basis for the majority saying, because an invention is just information and you can't have a property right in information, therefore, Dr. Thaler can't derive rights from that.
Well, why not? Why can't you have rights in confidential information and transfer those rights?
Well, I submit that you can, and that
what you call a property right or don't call a property right doesn't have some universal meaning, does it? Concept of property has different aspects to it. And information has something in common with other kinds of property and other things it doesn't have in common, in that more than one person can possess it at the same time, which you can't do with a pen or something. But whether you make that a criterion of property depends on the context.
Quite so. And so our submission is in this context. It is property. There's a property right in it. The Act gives it that. Even as confidential information, Dr. Thaler would have rights to it. The right to prevent unauthorized access, a chosen action if someone were to misappropriate it from him. You know, there are rights to be had in an invention.
Of course, when the application is published, then any interest in the invention as a sort of notional confidentiality-based right or something of that kind would melt away, because you now have an application and it's published.
Well, indeed. Prior to filing it, when this was information that, among other things, was confidential information, Dr. Thaler owned that. He could have licensed it as know-how. He could have destroyed it. He could file a patent application on it. But the point is, he was in exclusive possession of that information, and he had rights to it. Right? And so these are the rights that we seek to establish that he was entitled to under Section 7.2.
And what do you say those rights are?
Well, again, the rights are, it is ownable by a person, it is alienable, and you have the right to apply for a patent on it.
What is ownable and alienable other than in substance the right to apply for a patent?
Well, the right to exploit the invention in however a manner the transferee chooses to do so. So, for example, if he had assigned this invention to Siemens to make a commercial product out of it, Siemens could have exploited it internally without ever disclosing it outside of the company, maintained it as confidential information. They could have decided this is competitive with whatever other products, we're going to destroy it, and pretended it never existed. They could have filed for a patent application. I submit Dr. Thaler could have assigned his right to apply for a patent on this invention to Siemens, and that then they would have this right.
But again, we go back to Section 30, which specifically provides that any patent or application for a patent may be assigned or mortgaged, but there's no equivalent provision for the property in an invention.
Well, I submit, my lord, that assigning an invention or an employer having a right to an invention as distinct from an application or a granted patent, is a common practice of the United Kingdom. That one can transfer one's rights to apply for a patent, even if Section 30 is silent on that.
But again, that would present no difficulty, would it? If Dr. Thaler were the inventor, leaving aside any rights that may inure to somebody else because Dr. Thaler is employed, but put that aside, if Dr. Thaler were the inventor, he could assign his rights in that invention to a third party, and the third party could file a patent application identifying Dr. Thaler as the inventor and indicating how it derived title to that invention.
Well, precisely, right? And so I agree.
Can I just come back on this? The patents, the application for patents, property and inventions are all created by the Act. They don't, or are you saying that the property in the invention exists independently of the Act?
I think it is. I think, to the extent that the right is to apply for a patent, it is created by the Act.
But the Act does not say it's assignable. The Act specifically says that the patent and the application of the patent is capable of assignment. So you're saying it's implicit in the...
Well, I think Section 30 is not perhaps comprehensive in saying, it states there is a right to assign an application and a patent.
You mean they left it out by mistake?
Well, not necessarily by mistake, but I do think, my lord, that it is very common in patent office practice, as my lord, Lord Kitchen said, that an applicant isn't an inventor, doesn't have an employment relationship, and the inventor has assigned the right to apply to a patent to a third party.
More that you agree with your quote assignee to waive your rights of confidence. So to a limited extent, you waive the right of confidence in the information, and for which you could no doubt charge.
Well, firstly, my lord, I would say that information filed in a patent application only ceases to be confidential information at the time the application is published.
There's no question of it that an application for a patent is personal property capable of assignment because the Act says so. So we're looking at the position before the application is made and what the nature of the property that the Act says exists is.
And my
We're
lord,
trying to work out.
I would submit it is uncontroversial and related to our case that if I invent something, I can assign the right to apply for a patent on that invention.
No one's disputing that, but what Lord Richards is asking you to address is the stage before. No one is doubting. Section 30 tells us that you can you can transfer the right to apply for a patent. What about the invention that you say there is property in?
Well, the property right that we're concerned about there is, in the invention, is the right to apply for a patent on that invention.
Is that the only property right?
Well, it's the only right that we're concerned about in this case. Well, namely, as an invention, there is a property right. I propose next to discuss why Dr. Thaler is entitled to it. But the Court of Appeal majority thought that it was confidential information, and therefore you couldn't have this derivation. Dr. Thaler couldn't obtain rights to confidential information.
But if the only thing in which you claim there is ownership is the right to apply for a patent, is there any other content to the property right in the invention?
Well, again, Dr. Thaler owns and possesses the invention, and he can exploit it in however he so chooses. Again, he can keep it confidential, license it as know-how. He can destroy it. He can apply for a patent on it, right? Those are the rights that are relevant here to which he derives entitlement under Section 7.2b.
So you can keep it confidential, you can destroy it, or you can apply for a patent, or assign the right to apply for a patent.
Quite right. And I submit those are property rights. Or if you want to think of them as inchoate or quasi-property rights, nevertheless, there is a right there that we argue Dr. Thaler is entitled to.
And what is the nature of the property? Is it incorporeal personal property? Is that how you see it, or what is it?
I would call it an intangible property right, or an intangible inchoate property right. And again, I submit that there's been some lack of theory devoted to this, because in practice, the right people are concerned about is the right to keep it confidential or apply for a patent, and that is the right that is transacted.
Yes.
So, unless further questions on that, I propose to turn to how we argue Dr. Thaler is entitled to this bundle of rights, right? And again, Section 7.2b allows any rule of law to give someone preference to an inventor, and we claim several apply here, including, as my Lord Hod mentioned, accession. And this is a principle that is, sometimes called by different names, sometimes accession, sometimes the fruit of the tree. But the general principle is that if you own property generated by that property. If I own a fruit tree, I own fruit from the tree. If I own a cow that has a calf, I own the calf. If I own a 3D printer, I own the output of that machine. Our case cites to a number of cases where this principle is applied, but we understand it to be common ground that there is such a rule. The dispute is whether it exclusively applies to tangible property or whether it could also apply to intangible property. Even if there had not yet been a case at the time of the Court of Appeal judgment in which the principle was applied to intangible property, that does not mean the principle should not apply here. That's the very nature of the common law, that as it evolves, as new factual circumstances arise, to allocate rights in ways that are socially beneficial. Though as it happens, cryptocurrency is an example where this right does apply to intangible property. So Bitcoin is a type of cryptocurrency that is property under English law, even though it is just a bunch of ones and zeros on a distributed ledger. The person who owns the Bitcoin is the person who generates the Bitcoin through using a combination of hardware and software to conduct mining, which is much like the situation here with Davis. Dr. Thaler owns Davis.
What is the authority for that statement you've just made?
Well, Your Honor, I just became aware yesterday of a case that this month got handed down from the Court of Appeal, authored by Lord Justice Burse. It's Tulip Trading Ltd v. Bitcoin Association for BSV and others. We just shared a copy of the authority with my learned friend. We have copies here if if my lords would like to see
That's an
them.
appeal on a strikeout application as to whether the operator of the system owes a fiduciary duty to those who have invested in bitcoins, whether it goes in, does it go into the issue of property?
Well, yes, my lord.
I mean, in the end, this is a bit of a sideline, isn't it? Because we're actually concerned with the Patents Act rather than with Bitcoin. And I mean, the issues relating to cryptocurrencies are difficult enough.
Quite right.
Without, I mean, it's going to be difficult to present an analogy when we're concerned with an exhaustive statutory code.
Well, it is, I quite agree, Your Honor, it is an exhaustive statutory code, but one that at the same time opens the door to say someone can be entitled to an invention in preference to an inventor by virtue of any rule of law. And our submission is that there are such rules of law in the common law. They have been applied uncontroversially for a long time to tangible property, and they should apply, in this case, to intangible property, consistent with the purpose of Parliament in passing the Patents Act. This is an example, however, of where another court in the UK has found that there was property in Bitcoin and that the person entitled to it was the miner. But yes, our submission is that the purpose of the Patent Act is to promote innovation, promote people to disclose confidential information they would otherwise not disclose, and to promote the commercialization of new inventions as commercial products. And that all of these purposes would be served by allowing this invention to be patentable.
But it is, with respect, it is patentable because the controller has never resisted the notion that if there is a new device which is not obvious in relation to anything that's already in the public domain and can be put into practical application, it is patentable. The question is, how do you secure the patent under the statutory regime?
Well, indeed, but the position of the case, my lord, is that, while it's undisputed from the parties we have a substantively patentable invention, the Patent Office's position is no one is entitled to own this because there was not a human inventor.
With respect, I'm not sure at all that is the controller's position.
Well, the application was deemed withdrawn.
Well, indeed, but that's because you failed to satisfy the statutory requirements. But you have, in a sense, got a green light from the controller as to how to secure the grant of a patent in relation to these inventions, if that's what they are.
Well, respectfully, my lord, as we read the hearing officer's statement, and Mr. Jahan took the court through it, he acknowledged that Dabis was the deviser of the inventions, that it would be almost impossible to name anyone else in light of how it was described that the inventions were generated, and that Dr. Thaler was not the actual deviser, but, under European law might be considered effectively a deemed inventor. And so because Dr. Thaler, to his honest belief, could not list himself as an inventor, there was no way of completing this procedural requirement, right? And so it is this paper-thin procedural requirement.
Well, with respect to Dr. Thaler, it might be said he's framing his application in such a way as to make it extremely difficult for the controller to proceed with it. And if Dr. Thaler were to adopt a way of framing his application, as suggested by the controller, consistently with the terms of the Act, then it can be accommodated.
The controller has suggested that Dr. Thaler list himself as an inventor, even though it is undisputed as a factual matter that Dr. Thaler played no role in directly generating the invention or in identifying its, novelty and value. It would be untruthful of Dr. Thaler to state that. And in other jurisdictions like the United States, although we're not concerned about that here, that is grounds for a patent being rendered invalid.
Well, I understand you to be suggesting that there is a route that can be adopted, and this is your argument that you're making now based on Section 7(2)(b), is that right? Well, that Dr. Thaler can apply for a patent on the basis that he is the person entitled to the property and the invention, even though not the inventor.
Well, precisely. I mean, our submission is this. The statute requires the designation of the person or persons believed to be the inventors, and we argue that the literal and purposive interpretation of that is where you don't have a human inventor. The answer is simply no one, right? And that is what, after the hearing, the rejections, the amended Form 7 says. Identify the person or persons you believe to be the inventor, and the answer is no person. And nevertheless, because this is the output of Dr. Thaler's property, he is entitled to it by any rule of law under Section 7.2b. And in our view, for Dr. Thaler to state anything other than that transparently would be a dishonest statement.
Well, Dr. Thaler is there reaching a conclusion as a matter of law, whereas all Dr. Thaler's got to do, actually, is to explain what happened in his application.
Well, and my lord, in the addendum, Dr. Thaler did explain how the invention was generated and put at the end, he played no role in the actual devising of the invention, but the patent office could have said, on the facts as you've laid them out, you may name yourself, we are going to have a non-traditional basis for human inventorship. Like the European Patent Office, if you own a machine and you turn it on, that's adequate for us to call yourself an inventor. I mean, in this case, the facts are relatively simple in that Dr. Thaler was the user and the owner. But as Mr. Jahan referred to in the Siemens example, there could be thousands of people programming these machines, licensing pre-trained machine learning algorithms, different teams of people using them for different purposes, and no human being who would do anything we would traditionally associate with inventive activity. Right, and so Dr. Thaler's claim as a factual matter is he did nothing traditionally associated with inventive activity, and therefore it would be wrong to consider him a deviser. He built DABUS, he turned it on, he trained it, and it went off in different areas, came up with unexpected things, and notified him that these were valuable. And on the basis of that, he filed patent applications on them. But again, the European Patent Office's position on this was, that's fine, that's enough for us. If you own a machine, just name yourself. But I submit that is not consistent with inventorship law in the United Kingdom. And the European Patent Office, again, stated, just list yourself and state, I'm claiming inventorship by virtue of owning an inventive machine, and that will be sufficient. And that patent could then enter the UK through the European Patent Convention. To give a bit more background on the rule of law here, in addition to accession, we also claim that first possession could be a basis of Dr. Thaler's owner of the invention. If the machine makes an invention and if there's no one otherwise entitled to it, possession, exclusive possession, is another bedrock principle of property law, and we included in the bundle a few cases that illustrate this rule. J.A. Pyre v. Graham, which is at page 404, Lord Brown Wilkinson stated, to be pedantic, the problem could be avoided by saying there are two elements necessary for legal possession: a sufficient degree of physical custody and control, factual possession, and an intention to exercise such custody and control on one's own behalf and for one's own benefit, intention to possess. He further notes below, but in any event, there has always, both in Roman law and in common law, been a requirement to show an intention to possess in addition to objective acts of physical possession.
This is talking about real property, isn't it?
Indeed, my lord. So again, the cases in which this have applied to date, leaving aside the Bitcoin case, have involved
I don't quite know how you can transfer those ingredients to an area of law where possession doesn't create title. I mean, possession creates title in relation to land, provided you've had it for long enough. I don't think it creates possession in relation to other types of property, does it?
Well, I submit, my lord, again, as you say, in both real and personal property, first possession is a basis for ownership. It has not yet been applied in this circumstance. However, to the extent, that Dr. Thaler is not otherwise entitled to it, it is a rule of law that is applied to tangibles that could apply here. He's in exclusive...
What's the rule of law that applies to tangibles? Sorry.
Oh, that first possession is a basis of ownership of, for example, unowned goods or of found goods, as against the world except for the first rightful holders. Right, and so Dr. Thaler had exclusive possession first of this invention. He filed a patent application, which was an act of, dominion and exercising control over the invention. And so, in our submission, this is consistent with the traditional grounds by which one obtains ownership over chattels. You know, the issue of whether some of these rules should apply to tangible versus intangible property was one that troubled the Court of Appeal below a bit. You know, I submit that there is all the more reason, you know, where this achieves the purpose of the Act to apply the rule. Because let's say that I didn't have legal title to the lemons on my lemon tree, right? But I have physical control of it, it's on my land, I can build a fence, I can still enjoy my property and keep people from it. With an intangible like this invention, once Dr. Thaler publishes it, as in a patent application, unless he has legal title, there's no way that he can prohibit others from using it. So it would be a tremendous disincentive for the disclosure of confidential information, which is one of the core purposes of the Act. You know, finally, you know, Lord Justice Arnold, in my view, viewed the invention as confidential information and ruled that this wasn't an adequate law for ownership of an invention. And I would submit that the law of confidence is also sufficiently flexible to allow Dr. Thaler to be entitled to the invention on that basis. It was created through his investment. He had exclusive possession of it. He could have exploited it as confidential information. This was one of the rules of law discussed by Lord Hoffman in Yeda and by Lord Justice Jacob in the Court of Appeal below. You know, Lord Justice Arnold cited to a number of cases that weren't involving inventions or were involving foreign law for the proposition that one can't have property in an invention. You know, but respectfully, in this case, we argued that there is property in the invention and that the law of confidence is another common law rule that could give Dr. Thaler entitlement to this invention. My third sub-issue on this is that...
I don't know how that helps you, but still.
Well, so if there is a property right in this invention, as I believe seems to be a consensus, and the question is, how does Dr. Thaler find himself entitled to it, right? It must be through a rule of law. And the rules of law we have advanced are first and foremost accession, but also first possession, and also rights he has in the fact that this information is confidential information belonging to him, right? So he has rights to prevent unauthorized access. He would have a chosen action against people who misappropriate this from him. And so there are a bundle of rights, a bundle of rules of law that entitle Dr. Thaler, as against any third party, to ownership of this invention.
Yeah, I mean, that's the point. I mean, once he's got ownership, once he's got the property, then he'll have rights. It's the means by which he gets it.
Precisely.
And you've instanced, you say that there's an analogy with the possessory title.
Precisely, my lord.
That's one route. You've mentioned accession as discussed in the Court of Appeal. That's another route.
The third is confidential information, as I understand it. You're saying that the invention can be regarded as confidential, the rights to confidentiality in the invention is a rule of law which can be used as a basis for a patent being granted to him.
Precisely, my lord.
If there's no inventor who takes priority under A.
Precisely. And an invention is necessarily confidential information because the moment it is disclosed other than under confidence, it's no longer patentable.
Thank you.
And conversely, once the patent application is published, there's no longer any confidential information.
Precisely. And one's right then shifts to the right in the patent application and ideally the granted patent. So
and that's the basis of the patent system.
Precisely.
You disclose your invention in return for a monopoly for a limited period of time.
Precisely. Dr. Thaler here gave up his rights to have this as confidential information in return for, depending on the outcome of today's hearing, ownership of a patent in these inventions. And it was his invention to do that with, by virtue of owning the property that made it, exclusively possessing the invention, and by having it as his confidential information.
Under B, it has to be at the time of making the invention. The fact he loses confidentiality later doesn't take him outside that provision, you say?
Precisely, my lord. Unless further questions on this, I'd like to move to the final submission related to this third issue, which is regardless of whether or not you find there is a rule of law, as we would urge, the Patent Office did not have the authority to reject this form in the way that they did and to deem the application withdrawn. We submit that action went beyond Dr. Thaler's statement in what the Act requires, which is merely that one give an indication of how the rights are derived. And the Court of Appeal cited the Nippon Piston Ring case in this, where Lord Justice Burse, which is at page 85 of the Court of Appeal judgment, in paragraph 66, stated, no great detail is required to satisfy 13.2b. No document evidencing title has to be produced to satisfy the requirement of the Act. Moreover, and strikingly, given what has happened to Dr. Thaler in the present case, Mr. Justice Whitford, who was well aware of changes in law and practice brought about by the 1977 Act as compared to the 1949 Act, held that the comptroller does not have to be in any way satisfied that the claim to title which the applicant is making is good. So what then is the purpose of the twin requirement for identifying who is believed to be the inventor and providing an indication of how title is derived? Mr. Justice Whitford explains that too. The only relevance of this is put forward by Mr. Pumphrey, counsel for the comptroller, is this: on the public record there will be made available the information as to who is said to be the inventor in respect of any particular invention. And if the application is not in the name of the inventor, some indication as to the way in which the applicants say they gained their title. And so again, the finding of Lord Justice Burse here was that this is a procedural requirement where one only has to give an indication of how they derive their right. The comptroller does not have to be satisfied the right is good. They cannot ask for documents to support it. One needs simply designate the basis on which you come in. Section 7.2b, Section 7.2a, Section 7.2c, right? And here, Dr. Thaler gave far more than is normally required. This is what happened. This is the basis on which I claim title. I have a rule of law through my ownership, programming, and control of DABUS, and in our view, comptroller was obliged to accept this point.
With respect, at the moment, I'm still searching for a submission as to how all of this fits with the terms of the Act. Because if you were prepared to accept, and I understand you've now made an application for a patent in the name of Dr. Thaler as inventor, then in the light of the circumstances presented to us, as I understand the controller's position, the application would have been allowed to proceed. So the controller would have accepted that position. But if you don't adopt that position, you have to somehow fit yourself into the wording of the legislation. And at some point, I'd certainly be grateful for my part if you could address us in relation to the particular and specific provisions of the Act with which you have presently been held to fall foul.
Certainly, my lord. So, the latter situation applies. The reason we don't feel Dr. Thaler could be an inventor under UK law directly is that he was not the actual deviser of this invention in light of the facts under which this was made. But other jurisdictions, including now the European Patent Office, may have different requirements for inventorship. Some jurisdictions don't require an inventor to be a natural person. Some jurisdictions don't require an inventor to be listed at all, right? But that is not the case in the United Kingdom, so we do have to bring it within the Act, right? Our submission is that Dr. Thaler, under Section 7 and 13 does qualify. Under Section 7, because there is this property right, because he is entitled to it by these rules of law. Under Section 13, because the only requirement of the Act is that one give an indication of the person or persons believed to be the inventors and how someone derives their right. I submit that the literal meaning of that permits the answer, no person. If my university sent me a form and said, identify the person or persons who attended your lecture last Monday, and if no one attended, and if I didn't show up, I submit that a proper response to that would be, I identify no person, which is what Dr. Thaler did here.
With respect, the point, as I understand it, that you're still not grappling with is how this machine can be an inventor within the terms of the Act. That is to say, the machine absent Dr. Thaler. Because if you were prepared to put Dr. Thaler forward as the inventor, in control of this machine, that would be one thing, but you're not. The case we're dealing with is a very stark one, presented by your client as of choice, namely that the machine is the inventor within the terminology of the Act. And there is a good deal of reasoning in the decisions below as to how that simply doesn't fit with the Act on its proper interpretation.
Well, I submit, my lord, that the Act requires, one, designate the person or persons believed to be the inventor, and in a case like this one, where there is no traditional human inventor, then the requirement of the Act is that one simply designate no one, and so that the inventor on this application have no person.
There is no inventor.
There is no inventor, right? So that was the amended Form 7. You know, different jurisdictions might accept Abbas as an inventor. South Africa has, Saudi Arabia has. But the UK Patent Act and the amended Form 7 says the inventor is no one. There is no human inventor of this application. You know, as we addressed in the supplementary...
So you don't need your submission is you don't need an inventor to get a patent.
Precisely. The
I
requirement...
understand you to be saying that 7.2b allows somebody who's not the inventor but who acquired the property in the invention by means of owning the machine,
Precisely.
to be a person who can apply for a patent.
Precisely.
If that were correct, then you say it would be wrong that Section 13 should be construed in a way that prevents that happening just because he can't say that somebody was the inventor if he doesn't believe there was anybody to be the inventor, when that isn't necessary on your case in order to obtain a patent under Section 7.
Precisely, my lord. And not only do we submit that the literal interpretation of Section 7 allows for no inventor where there isn't a human inventor, we submit that the proper approach to this from a statutory interpretation perspective, would follow the judgment in Quinta Valle, which involved whether, protections on human embryos. And Section 1, subsection 1 of the Human Embryo Act of 1990, only governed explicitly embryos that were fertilized, because at the time it was thought that you would only be doing work with fertilized embryos. When a technological development came along that made it possible to have non-fertilized embryos through nuclear replacement, even though this directly contradicted the literal language in Section 1, subsection 1, the House of Lords found that this was a comprehensive regulatory regime. Parliament had intended the act to apply to all human embryos. The fact that this literally didn't meet the definition was of no consequence. It was designed to address a certain mischief, and the intent of Parliament was to cover this comprehensively. I submit in this case, as Lord Justice Burse very helpfully outlined in the Court of Appeal judgment, the purpose of the Patent Act was to, as we discussed, promote innovation, disclosure of trade secrets, and to commercialize new inventions. And now the technology has developed to the point where you may not have a human inventor anymore. These inventions should not be unpatentable because someone can't fill this form out properly, or is forced basically to lie on it, right? Or at least not state their honest belief.
I think your submissions would necessarily mean we'd have to disagree with what the House of Lords said in Yeda.
Well, in Yeda, Lord...
I'm thinking in particular of paragraphs 18 and 19 in Lord Hoffman's speech in Yeda, because he says, for example, that Section 7.2 emphasises that a patent may be granted only to the inventor or someone claiming through him, and that an inventor is the natural person who came up with the inventive concept. So, I mean, we must face this, that we would have to say that a unanimous decision of the House of Lords was wrong in that respect. No doubt you'd say because they didn't fully grasp the impact of subsequent technological changes.
Well, respectfully, I would disagree with that. Right. Lord Hoffman did state that an inventor is a natural person in that case, but that was a statement made in dicta. No one was arguing in that case that an inventor would be other than a natural person.
So are you saying that 18 and 19 is dicta as well? Sorry, it's page 465 in the manual.
No, parts of it. I mean, I would state that the comment about a natural person was dicta. No one in this case was alleging that an inventor was other than a natural person. Not only did it not involve an AI-generated invention, which of course wasn't an issue then, no one was alleging that a corporate entity or a state, for example, was an inventor. This was only an entitlement dispute involving individuals or people claiming through individuals. And Lord Hoffman, may have used the term or claims through the inventor, but one could have a semantic discussion about whether one derives rights through DABUS by virtue of owning DABUS, or whether...
I understand the point. I'm simply pointing out, for your comment, that we do have to, as I see it, disagree with what Lord Hoffman said.
For my submission, my lord, I think that Lord Hoffman's statement that an inventor is a natural person was in the context of this case and was not in any way designed to be...
It was wrong, you said. It was wrong.
At the time, I think in relation to this case, it was correct. These were natural persons being inventors. He was explaining the basis on which the two institutions suing, YEDA and the UK institution, how they were fighting over entitlement.
I mean, the point he was making is that an inventor couldn't be a corporation. And if an inventor can't be a corporation, it's difficult to see how it can be a machine.
Well, so in that case, my lord, as I understood the positioning of the case, you had YEDA on behalf of the Weizmann Institute arguing that they were entitled to a patent by virtue of their employment of certain scientists, and a UK institution claiming they were entitled to the invention by virtue of employment of their scientists. So while the companies were properly entitled to it, no one was debating that the rights were coming through inventors. The question was whether the UK inventor had breached a confidence to file, to allege inventorship, or who the true inventors were as between these two groups of scientists. But there was never any contention that one of these organizations was an inventor. In any event, I would state that a corporation is quite different than an AI, because an AI, on the undisputed facts of this case, independently and autonomously devised the invention. And a corporation could not do that because it is composed of the individuals who work for the corporation. And one of the reasons, there's effectively two reasons to name an inventor. One is to give the public an indication of a derivation of rights, particularly where some other party may feel entitled, as in this case. When the UK scientists organization applied, YEDA caught the patent and said, actually, he was never, first they said we were joint inventors, then they said he was never an inventor. They were fighting over ownership of the application, precisely because the disputed inventors had been reported on the register, right? And the other is in a case where an inventor is a natural person, that person, has an interest in being named and given credit for having devised something, right? Where that wouldn't apply here. DABUS has no interest or rights, and that has never been our position. But I think this case is distinguishable from YEDA on that basis.
What would happen if Dr. Thaler got a European patent? Could he use that as a springboard for applying for a patent under 7, or does it not operate like that?
Well, my understanding, my lord, is that the patent would automatically take effect in the UK, and based on the revised submission, the submission says, in inventorship, Dr. Thaler, by virtue of owning DABUS, and then explains why Dr. Thaler is a deemed inventor. That patent, if granted by the EPO, would, as I understand it, take automatic effect in the UK, and so you would then have this interesting situation where that patent would, in my view, not be consistent with Section 7 or 13 of the Patents Act. Section 13 of the Patents Act.
With respect, that's not the position the Comptroller is taking, as I understand it. If you had adopted that course in the UK, in England, this would have been allowed through.
Well, my lord...
But it is with respect, because you've taken this rather intransigent position, or might be seen to be a rather intransigent position as to how you have framed your application, that you've run into a brick wall.
Well, respectfully, I would disagree in two senses with that. One is the Comptroller now seems to be taking that position. The hearing officer took a very different position. The hearing officer understood how this operated, understood that Dr. Thaler was not an inventor, and stated as much, and then said, and you can't name Dr. Thaler as an inventor. So that is in the hearing officer's report, which Mr. Jahan read. My second point is, what might be intransient to some might be, Dr. Thaler simply stating his honest scientific belief. And, as Mr. Jahan walked us through, not an unreasonable one in light of advances of technology and what other organizations are reporting. And I think that this is all outside this case based on the assumed facts. But there are organizations like Siemens reporting, as in the bundle, they have this happening, they can't identify a human inventor, and they can't file patent applications. And the UK IPO mentions that no one else has filed a patent application like this yet. And yet before our hearing, they amended their manual of practice to say, if you list an AI as an inventor, your application is getting rejected. So for Siemens, who doesn't have a human inventor willing to say that they invented something, Siemens can no longer use AI to optimize industrial components if it is going to be commercially valuable and if they need a patent on that. And GSK will not be able to use AI for drug discovery and repurposing.
Well, that is all on the assumption which we're required to make in this case, that the AI system is the creator. But we're not going into that.
Indeed, quite right.
That's just the assumption on which we have to operate.
But to the extent that the case is that Dr. Thaler really ought to just name himself, I submit that that would be dishonest, firstly, in his belief. And secondly, that is an objectively reasonable position in light of the current capabilities of artificial intelligence. None of that was put into question by the hearing officer, who accepted the statement, who accepted how the invention was made, and who said, Dabbis was the actual deviser, Dr. Thaler, you cannot be the inventor, and I'm just going to deem this application withdrawn. Although Dr. Thaler's position has been nothing but consistent, he believes he's entitled to it, it is otherwise patentable, this would promote the purpose of the Patent Act, and it's just this part of Section 7, this Form 7, that is prohibiting all of this from working as it should. And that is not consistent to the extent you think it is not a literal interpretation of the Act. That's not consistent with the purpose of the Act.
Well, can I just put something to you, that the purpose of the Act is to incentivize individuals to invent things.
So I would respectfully disagree with that on three bases. Lord Justice Jacob, who discussed this in Yeda, was very fond of noting that in his view, the most important purpose of the Patent Act was not innovation or disclosure, but commercialization of new inventions. So if you have a company like GSK making a new drug, the act of invention may not be so expensive, but the act of commercializing it may cost billions of pounds. You have to run these very expensive clinical trials, and without patent protection for that sort of thing, you just won't have a market for it. So patents can be vital in commercialization. Second, patents promote disclosure of information, as has happened here, right? If applicants can't file for patents on these truthfully, or without other consequences, or get patents, they can choose to maintain it as confidential information and license it as know-how and exploit it internally, but that denies the public a benefit. The third, as you say, is it promotes innovation, but it doesn't have to directly incentivize inventors. I mean, most patents are owned by corporations, and the financial benefits flow to them, and they fund innovation by employing people. So the benefits, are often indirect to people. Here, of course, Dabbis needs no incentive, but organizations using AI to make and use inventive things do need incentives. We want them using these AI systems, particularly in areas where the AI may outperform a person, for example, in drug discovery and repurposing, as the first instance decision in Australia discussed at some length. So although we're removed from directly incentivizing an inventor, the incentive is just as important here.
We use all sorts of extraordinarily sophisticated technical tools to make inventions. And AI may be an extreme example of that. So I'm puzzled myself at the moment as to why it's inappropriate to describe Dr. Thaler as the person who programmed and set this thing off along its track, as at least, to identify him as at least an inventor. But there it is. I mean,
Well, my lord,
I've understood your submission.
I would make 2 points on this. I think a good analogy is a self-driving car, right, which is a tool. It was programmed by people. It takes me from my house to my work because I tell it to, but it is automating a task of driving in a way that only a human being used to do. Well, now we have inventive machines. And yes, a human being built it, and yes, we're supplying it with electricity and turning it on, but it is automating the thing that used to make a human being a deviser. And programming DABUS without any expectation that it would generate a fractal container or this emergency beacon, I submit, was not proximal enough to the inventive act to be considered inventive skill. And our case has a clear factual underpinning, which makes the legal issue a little easier. But I submit that there are many organizations that license pre-trained machine learning algorithms that might do this sort of thing, and the programmers may be very removed from what someone is using to actually make something. The programmers may have no idea of, what someone's using it for. People at Siemens or Google might, invent an AI to optimize industrial components.
Well, maybe the circumstances are different, but we're dealing with a particular case here where Dr. Thaler programmed this machine and set it off on its track, and it's come up with these 2 inventions just as Dr. Thaler hoped and intended it would.
Hoped and intended it would generate inventions, but not these specific ones. And, well, my lord, I agree that the hearing, the comptroller could have said, while this case has never arisen before, in a case where someone programs an AI and you don't have a traditional human inventor, even if you had no idea what it would come up with, and even if it said these inventions are valuable, maybe I take that as a basis of inventorship, but on the basis of the explanation that all of the traditional inventive activity was done by the machine, the hearing officer found, and I submit appropriately, that the actual deviser here was not a person. And therefore, Section 13 would be appropriately filled out by simply indicating there is no person or persons believed to be an inventor.
That's the nub of this appeal, isn't it?
Yes.
That's the point you've made there.
That's the rub. Section 13 just says, give an indication of who you believe to be the inventor.
The person, it doesn't.
The person. And here, no one. There is no one.
How have you complied with the section?
Well, if it says identify the person or persons you believe to be the inventor, and there is no person believed to be the inventor, that is an answer I would submit, my lord, to that question, both literally and purposively, particularly in view of the statutory interpretation principles of Thaler, which is either answer this dishonestly, in your view.
No dishonesty involved. It's how do you comply with that provision, that requirement?
Well, in our case, where it says identify the person or persons believed to be the inventor, our answer is no person.
Yes. Or you say not possible.
Well, I submit that an answer to identify this group of persons where there is no person in the group, an answer is no person.
Well, might another alternative be to say that the closest human to the creation of this invention was Dr. Thaler?
I would submit that that the law of inventorship in the United Kingdom requires a person to undertake a certain activity and exercise some amount of inventive skill with relation to an invention. And saying the person with the closest nexus to the invention could be someone very far removed from this. And the Act requires that an inventor be an actual deviser. I think that is key. Because if the law said, and this has been the approach of the German court, name the person with the closest nexus to the invention, but it doesn't say that. It says you have to name the actual deviser. There is nothing Dr. Thaler did directly to devise these 2 inventions. He just built an inventive machine, and he could have licensed it to someone else, and he may license it to someone else. And if these patents are protectable, other organizations may run DABUS and generate inventions.
The reason, perhaps, why the section requires the applicant to state who they believe is the inventor is that the whole basis of the Act is that the inventor is a person, specifically, actually a human being. And that's the underlying premise of the Act.
I would submit, my lord, that there has always been an assumption that human beings have been an inventor, because that is the way it has always been done. But that the true purpose of the Act...
I mean, the Court of Appeal, Lord Justice Arnold's judgment, and I think Lady Justice Lane, refer to quite a number of provisions in the Act which specify that the inventor is a person. And so Section 13.2a just fits in with that architecture of the Act. How do you respond to that?
Again, my lord, my submission is that while there has been an assumption that inventors have been individuals, where there is not, those sections still work, right? Dabis is not entitled to rights. There's no right to employee compensation in a case, and this is why we don't name a person, right? So provisions like an employee where equity requires it is entitled to compensation would simply not apply in this case. So we believe the purpose of the Act, again, my lord, in my view, is very much not to give something specific to individual inventors, but to provide an economic stimulus to promote these socially valuable activities that are now, with the evolution of technology, being automated, and that is something the law ought to, under the purpose of the Act, the law should be interpreted to encourage it.
Yes, that's very clear.
I think, unless my lords have further submissions, I believe we're at the end of our time.
You are indeed, Professor. Which thank you very much. Dr. Bowden.
I'm grateful. My lords, as you've appreciated, this appeal centres on certain issues of statutory interpretation, and the issues themselves are relatively well circumscribed ones. His Majesty's Controller's central contention is that much of the answer to their interpretation lies in the words of the Act itself. But nevertheless, in order to place those in some context, I do propose very shortly to take you briefly through some of the genesis and the history of the 77 Act and of those provisions relating to inventorship in particular, as well as just a little of the European context as well. That's not because the Controller contends that this history shows the statute should mean something other than what it says, quite the opposite, in fact. But the purpose of exploring some, of the basis and context for those provisions is to seek to illustrate why they say what they do, why Parliament can safely be said, and should safely be said, to have taken to choose its words, and it's centering those provisions on persons with consideration and care. Just to explain where I propose to go after doing that, once we've looked at the background, I propose to deal with Section 13.2a first. That will take in issues A and B as set out at the end of the Statement of Facts and Issues, about whether a person need always be named as the inventor and whether patents can be granted where there is no human inventor. Then I'll move to 13.2b and the requirement that the non-inventor applicant must supply an indication of the derivation of his right to apply. That will cover off issue C. But before getting to sections 13.2a and b themselves, there are certain points that I propose to deal with up front, because they're not particular to one of those issues, but sit prior to or indeed above them. One is briefly to emphasise what this appeal is not about. As I said at the very beginning, the Controller considers that this is an appeal about what certain provisions of the Act mean in their proper context, and whether the hearing officer correctly applied that law as it currently is in force. The appellant has made its points about how the words of the statute should be interpreted, and I'll engage with those directly. But in my submission, the appellant has also at points shaded into arguments that really go to what Dr. Thaler considers the law should have been, what Parliament ought to have legislated for reasons of policy. And there are several reasons why, in the Controller's submission, my Lord should not take up an invitation to reinterpret the Act based on such broad considerations of policy, but if it pleases, I shall deal with those after we've looked at the context for the provisions that we do have. So to that context, I say entirely without shame that I'll take the structure of much of this from the judgment of Lord Justice Birse in the Court of Appeal. It's his paragraphs 32 to 45. And I do that because the Controller doesn't quibble with Lord Justice Birse's account of the legislative history in the sense of what the provisions were and what the relevant committee recommended. The Comptroller only disagrees with the reasoning that Lord Justice Birth then extended starting from that history, but of course we'll come to that later. So first is, unusually in a patents case, as Lord Justice Birth said, the Statute of Monopolies of 1623. That's in the core bundle at page 346. I shall take all of this relatively briefly, but the key points here are on page 347, in fact, sections L and then 6. All monopolies and grants, etc., thereof, or of dispensations and penalties declared void, and then in section 6 below, there's a proviso for future patents. The proviso provides for grant of patents to the true and first inventor and to nobody else. Until the 20th century, it wasn't possible to assign the right to be granted a patent. It only vested with the true and first inventor. But in that context, the words true and first inventor didn't just mean what we might think of that to mean now. It included both a true and first inventor in the sense we might imagine today, namely the first person who invented, devised, came up with the invention, but also true and first importers into the realm. So the true and first importer, for the purposes of this proviso, who was entitled to be granted a patent, might just be the first person who imported it into the realm, regardless of whether they were involved in any way with its devising.
Invention by importation was quite a well-known way of securing monopolies.
Quite so, quite so. And that's something that then changed with the 1949 Act, which is where we go next.
So, if you were the actual first inventor, could you come along and displace that, or was it just your bad luck if somebody else imported it?
As I understand it, if you weren't the first person, no, I don't think you could. I don't think there were mechanisms for that under the Statute of Monopolies, but I won't pretend to be a legal historian that can give you chapter and verse on that. Certainly, when we get to the 1949 Act, those sorts of mechanisms are provided for. So that's at page 340. So at this point, under section 1, applications could be made by a person claiming to be the true and first inventor or by their assignee, A or B. So as Lord Justice Birth noted, that was a significant change. The right to be granted a patent was now assignable. But when the assignee applied, the true and first inventor had to give their assent to that application in writing. And that, on the opposite page, 341, for those of you looking electronically, is section 2 sub 2. Finally, section 2 sub 3 required that every application had to state that the applicant is in possession of the invention. They had to name the person claiming to be the true and first inventor, and they had to state that the applicant believed that that person was the true and first inventor. Very importantly for present purposes in my submission, we then come to section 16 on page 342. This introduced the concept of mention of the inventor. A couple of points on this provision, first of all. If we look at 16 sub 2, as is the case in the current 77 Act, which we'll look at later, it's clear again that the actual deviser is a person, and Lord Justice Birth drew attention to this too, since 16.2 refers to the actual deviser of an invention or part shall be deemed to be the inventor, notwithstanding that any other person, i.e. a person in alternative to the first person. So this appears to be clear that the actual deviser of the invention was considered to be a person. The only right that this section specifically confers on the actual deviser, an inventor in the more current sense, is the right to be mentioned as the inventor. We'll see this come up again and again from this point. It's a moral right. It's a right to get credit for what you've done. A right which, in my submission, can only vest in a person. And that right has been central to the concept of why we identify the actual deviser for the purposes of a patented invention since the 1949 Act in my submission. And we'll see it in the European provisions, just as we'll see it in the 77 Act today. Finally, to meet the question from Lord Leggett a little while ago, grounds of revocation under the 49 Act are provided under section 32, which is on page 344. There are two in particular of relevance here, sub B and C, and they apply in situations where first the patent was granted on the application of a person not entitled to apply, that's 1B, and then 1C, that it was obtained in contravention of the rights of the person coming along to quibble about it. Those two grounds overlap. The first was able to be raised by anybody, and the second only by the person who said that his or her rights had been contravened.
So one could secure a transfer of the right, or would that inevitably result in revocation?
It was revocation, this provision. It was an inevitable revocation, and that's something that changes later on.
Yeah.
That's something that we see addressed specifically in the Banks Committee report, which we'll see shortly, which led to the 1977 Act, was that patents didn't get lost because the wrong designation had been put down for who the inventor was, for example.
Yes.
We'll get there very shortly, I promise.
More likely somebody had pinched it.
Well, perhaps so, yes. But there's express mention in the... We'll get there in a second. There's express mention in the preparations for the 77 Act for bona fide mistakes or bona fide misstatements as to the inventor. The worry under this provision was exactly, my lord, as you identify, that the patent would be lost and couldn't be transferred because it would just be revoked. And so that's something that changes later on under the 77 Act. Now, the next relevant UK Act is the one that we're concerned with, is the 1977 Act, the one that's currently in force. But there is something else I'd like to look at first, not so much by way of history, but international context. There's no dispute that, as indeed Lord Justice Burst noted, a very great deal of the 77 Act was passed to comply with the European Patent Convention, the Community Patent Convention, and the Patent Cooperation Treaty. And section 130 sub 7, which you were taken to by my learned friends earlier, lists provisions in the 77 Act that are intended to have that effect. They're intended to bring about our compliance with the European instruments. It's notable that sections 7 and 13, the two on which the present appeal really centres, are not in the list of provisions in section 130 sub 7 that are there to match with the EPC. But nevertheless, as Lord Justice Burst said at paragraph 40, agreeing with a decision of Mr. Justice Arnold as he was then in a prior case, Abbott and Medinol, it's generally undesirable for us to interpret the UK Patents Act differently from corresponding provisions in the EPC in particular, unless there's a jolly good reason, given the internationally cooperative nature of the patent system we're talking about. And so for that reason, just before we move to the committee findings and changes that were made to lead to the 77 Act, I would like just to highlight some relevant provisions of the EPC. So if we start at page 357, some of these provisions you've already seen, and I will take them very quickly. Article 60 provides for the right to a patent, which shall belong to the inventor or his successor in title.
When was this system created?
The European Patent Convention was concluded as the 1973 convention. This version was concluded, it's called the EPC 2000. I believe it came into force on the 7th of February 2008. So Article 60 provides for the right to a European patent which shall belong to the inventor or his successor in title. Then across the page, 358, is Article 62, I mean, the first point I should have made, sorry, about Article 60, of course, it's framed as a right. And of course, it's persons that have rights and not machines. Article 62 provides for the right of the inventor to be mentioned. Like the 1949 Act, which we've already seen, this provides for what's sometimes referred to as a paternity right, a type of moral right. Now, calling these things moral rights, that sort of formulation is perhaps a little less familiar to us in the Anglo-Saxon legal tradition, in intellectual property at least. But in continental jurisdictions, it's a particularly important way of looking at these things. A moral right to be asserted as the inventor of the invention, of getting credit for what you've done. And we have similar provisions for moral rights provided for in the realms of copyright as well, the right to be asserted as an author. But the crucial thing here, it's a moral right conferred on an inventor, an actual deviser, and only on an inventor. So clearly, again, the inventor must be understood to be a person, because machines don't enjoy rights, and certainly not moral rights. That applies to the 49 Act, and here to the EPC, which sits in a sort of supervening position over the national law, which you're asked to apply. Pausing for a moment, another important point about this provision that was alighted upon by the Legal Board of Appeal in their decision in this case that you were taken to earlier, is that the EPC confers rights on the inventor to be mentioned, but it never considers a right of third parties to know who the inventor is. So there's express provision that the inventor has a right to be credited, to be mentioned, which he or she may in certain circumstances choose to waive. And indeed, he or she may choose to do that by not exercising a right to apply for a patent at all. They may choose just not to enter what this court has often referred to as the patent bargain at all. So rights of the public, prayed in aid quite heavily by my learned friends, aren't really provided for in this scheme, as the Legal Board of Appeal noted. It's not framed as a right for the public to know who invented the invention. It's a moral right bestowed on the person who's the inventor, to be mentioned as such should they wish. Finally, for the EPC, we have Article 81, which is on page 362 of the bundle, and the accompanying rule, which we'll go to shortly. This provides that the application for a European patent shall designate the inventor. And if the applicant isn't the or a inventor, they shall include a statement indicating the origin of the right to the patent. So this is a broadly similar structure to Section 13 that we're considering. And also, it's clear why they must designate the inventor. They must designate the inventor because we've already had it provided that that person is entitled to the moral right to be mentioned. The accompanying rule that goes with this on page 365 of the bundle is Rule 19, which you were shown earlier on. Its paragraph 1 provides for a series of requirements about precisely what details should be given. Paragraph 2 is quite important later on in my submission. The European Patent Office shall not verify the accuracy of the designation of the inventor. It doesn't say they shan't verify whether one has been designated. It doesn't say they shan't verify whether an adequate answer has been given. It says they won't verify the accuracy. Is the person they've named the right person is not a question the EPO will ask itself. Nor, in the UK context, is it a question the controller can ask himself. And that's a distinction we're going to come back to several times this afternoon. So that's all I propose as an extremely brief tour of the European Patent Convention and its relevant provisions. The next place to go is the Banks Committee report. The Banks Committee was a committee that produced a report to Parliament on the British patent system, and it's the committee report which led in substantial part to the 77 Act taking the form that it does. The report itself is in the second bundle, is at pages 746 to 751. That's right, yes. I wonder if I might just ask you to read briefly paragraphs 525, which starts on 749, 525 to 531. If I could ask you to read those briefly, then I'll make some very short points about it rather than reading it all out to you.
525.
525 to 531 inclusive, and then we'll look together at the recommendations that follow in bold text. So if it pleases, at the end of 528 we have the concern raised by Lord Kitchen a moment ago that the failure, even a bona fide failure to comply exactly with the formalities, would appear to result in the patent becoming liable to revocation. That's the problem we saw with the 49 Act when we were there a moment ago, and so that's something that's proposed to be dealt with, and then a series of simplifications are proposed. And the recommendations then are in bold text in the middle of page 751. We have, first of all, that the inventor should be the actual deviser of the invention instead of the true and first inventor with the expanded meaning we've seen. Second, that the application for the patent can be made either by a person claiming to be the inventor or by someone else claiming to be entitled to the benefit of the patent when granted. We don't need to concern ourselves with convention applications for present purpose, which is sub B. Importantly, they want to say that the making of an application by someone other than the inventor shouldn't imply in any way that the inventor has assented. And the applicant should name those believed to be the inventors, and they should be named in the public specifications. This is to meet the requirement for the moral right to be bestowed on them that they deserve to be mentioned for what they have done. The requirement that the inventor assent under section 2.2 should be abolished, and section 4.5 dealt with declarations of inventorship. We don't need to be concerned with that. So in substantial part, this series of recommendations is what led to the structure of the provisions in the 77 Act that you've been looking at with my learned friends this morning. We will, of course, look at them again in detail as we tackle the issues under 13.2a and 2b. But the key point at this stage that I would like you, if it pleases, to take from this extremely speedy tour through the context is that an integral part of the idea behind identifying the actual deviser in particular was to confer on him or her a moral right to be mentioned as the inventor. And that moral right is one that only is to be bestowed plainly, I say, on a person. Machines don't have rights, and they certainly don't have moral rights. My lords, I have an eye on the time. I'm certainly happy to keep going, but that is a full stop if it's a suitable full stop.
Well, given that you're moving away from the bank's report, that seems to be a convenient point at which to take the short adjournment. The court will now adjourn.